Government's legal advisors are studying the ruling of an international court with far-reaching implications for Ghana's oil wealth. The International Tribunal on the Law of the Sea issued a preliminary verdict over the weekend in the maritime boundary dispute between Ghana and Ivory Coast. The main thrust of the verdict was that Ghana should continue with whatever she is doing, but the country is however prohibited from drilling any more wells. So what does this mean for Ghana's crude oil reserves in the disputed area? This is today's big story, and my name is Ayah. We'll be back shortly. There are some legal brains who believe the ruling by the tribunal is an indication Côte d'Ivoire has a case and that the verdict in the substantive matter in 2017 may eventually go in their favor. But former GNPC boss and renowned lawyer Chatuchi Kata is however of a different opinion. He believes Ghana has a solid case grounded on the way Côte d'Ivoire has related to Ghana and other third parties as far as the disputed area is concerned. Let's listen to him now.
If you're going to be producing the oil from those existing wells, then you don't have a problem. Once you are just engaged in production from existing wells, even if you have to bring additional infrastructure, you are covered by the ruling. Now, again, let me highlight something that happened in this Hamburg proceeding. The Ministry of Finance, and again, I think the Ivorians probably just didn't take that seriously enough when it was happening. The Ministry of Finance, I think Dr. Junsu also was part of Ghana's presentation. He put out a written statement that quantified the extent of loss that there could be to Ghana in terms of jobs, in terms of revenue, in terms of the whole sector development, and this statement highlighted the fact that Ghana had invested a lot of resources, in terms of the oil industry development. Now, 10 was the highlight of that, but it wasn't just 10. It really, there was an indication of job opportunities and the way in which the revenue from the oil went into infrastructure development and all that. So I think that had a major effect on the mind of the tribunal, which is why from some of the passages that you heard me read, the tribunal acknowledged the extent of loss that would be caused to Ghana and therefore did not go along with the Ivorian position. I think what is now needed on the side of both sides, in terms of the order of the court, what is now needed is that on the Ghana side, for instance, looking at the work that's already been done in the so-called disputed area, if there were plans, for instance, to go into production from any of the wells, then you've got to project the fact that if, say, you start production from some of the wells that you've already drilled, how long will it take for you to require new wells in order to sustain the level of production that you are going to be starting? And, considering that the final decision is going to be taken by 2017 in this tribunal, it means that there's not such a long time. So you can indeed go into production in some of those things, knowing that after the final decision, middle of 2017, you then are likely to go forward with whatever additional drilling you may require. So it's actually going to be an interesting situation for GNPC and the Ministry and Petroleum Commission and so on to look very closely at what is going to be Ghana's strategy going forward for either increasing our production from existing wells or what are we going to do? And I think there's a lot of technical capability that Ghana has to address that.
But private legal practitioner Samson Ladi Ayunini warns Ghana must not be complacent and gloat over the ruling of the injunction because there could be a tougher challenge ahead.
it is good to hear that the phase 1 developments, as far as the 10 project is concerned, are done, that we have 10 wells, is it? That's all that is needed for now to make that $5 billion, project, US dollars project, worth the while. That is good. If there will not be new drillings, that is fine. But when you hear information that suggests that there are machines on the way and that are intended to do further drilling for this same purpose, then you get a bit worried. And those who are arguing that may require further clarity from the court as to whether or not it is permissible or allowable for new, drillings to go on to complete the 10, field. I repeat what I said earlier, that if there ought to be any additional drilling to make good sense and make the judgment or the order operational, that is a consequential drilling and ought to be allowed. It ought not be hindered. However, I say, for as long as Ghana has had exclusive control, for over 4 decades, that means a big deal in both the application of the equidistance and equitable doctrines. So a lot will go for us. But since the tribunal, didn't deem their claim frivolous in the plausibility test, which I agree is a lower standard as compared to the establishment of a prima facie. But that gives me a sense that the guys appear to have a case, and that if we are not careful, we may end up with a final decision that mimics this preliminary one, which is sort of 50-50 depending on how you look at it. Nonetheless, I just hope, and I have a lot of hope that we will succeed.
So what does this mean to Ghana's oil exploration? Joining me on the phone is lawyer Kwame Junsu. Good evening, sir. Many thanks for your time.
Good evening, and good evening to fellow Ghanaians.
Yes, we've just heard what these two lawyers have said, but let me ask you, does this ruling...
Unfortunately, I couldn't hear them when they were talking.
But looking at the ruling, does this ruling strengthen the position of Ghana?
Well, it's only a ruling to stop the injunction that Ivory Coast had placed in terms of not allowing tallow to start exploration activities in the 10 project. And so it is just preliminary. It's just taking away the injunction so that tallow can go ahead with the 10 project. When you look at what the judge said, in a nutshell, it said it would cause considerable financial losses to Ghana and its concessionaries, and could also pose a serious danger to the marine environment, resulting in particular from deterioration of equipment. So based on that, it can tallow can go ahead and do the exploration for the 10 project. But I don't see how it affects any. Rather, if the judgment had gone against Ghana, then within that line, you have Hess Petroleum. Hess Petroleum has got 7 discoveries so far, and they are working to announce commerciality by 2016. You have AGM also there. So it would have probably strengthened the Ivorians to also go for Hess and go for AGM. AGM is a new field that has been given out, and they are yet to start exploration. So in a nutshell, yes, it's good for Ghana.
Well, let's look at Ghana's oil exploration in itself. What does this mean for us?
Well, what it means is that we have been given the mandate to start the 10 project. The 10 project is estimated to produce 8,000 barrels at the end of 2016 per day. and now Ghana has 20% in there, and so production can start. Nothing is going to stop us there. What we're looking at is the final verdict in 2017. Now, that doesn't stop us from doing what we have to do now. Come 2017, if it then goes against us, then that is another case that we have to look at. However, I have said, and I intimated this, on several stations this morning, that if we are looking at the activity map of Ghana, it stretches from the Ivorian side, which is the west, right up to the Togo side, which is the east. When you look at the two boundaries, it has been laid in the same fashion. So, if it so happens that on the Togo side, there has been no legal agreement with regards to the boundary there, this is the time we should start looking at it. Because we do not want a situation where we are now going into the similar kind of situation we are having with Côte d'Ivoire. So I think it is time that we looked at the two boundaries and made sure that we secured the Togo side. The Ivorian side is in court at the present moment, and there's not much we can do till the hearing. But isn't it strange that the UN extended Ghana's maritime and nautical miles by 200 southwards? On the same side of the Ivorians too, they did the same, using this boundary line. Now, if the UN felt there was a dispute, why would they do that? I ask myself.
Lord Jantua, let me hold you on for a while because my colleague Israel Ayah is in the studio with me. And Izzy, you have been following this issue for some time now. Kindly lead us to events that eventually led us to our current situation.
Okay, so we, at some point in time, the Ivorians were making some posturing. There was some posturing from the Ivorians that government felt that we had to take some steps before it got to a point where probably we're going to lose out big time. So government decided that it was going to take this thing to the International Tribunal on the Law of the Sea and try and get this thing resolved. Initially, there were some negotiations that had started, but somewhere along the line realized that it probably would be best if it went to ITLOS. And it went to ITLOS, and whilst ITLOS was considering the matter, which eventually we know that the verdict or resolution is going to come years from now, 2017. Then Ivory Coast came in and said, no, they wanted, whilst ITLOS was going to decide the matter, the tribunal was going to decide the matter, it wanted the tribunal to also place an injunction on our activities, which was whatever we were doing in the area, whatever exploration or exploitation we were doing in the area, it wanted the tribunal to stop us from doing that. Indeed, and I can go through the kind of things that Ivory Coast was looking for. They call them provisional measures. So the provisional measures are 5 in all. Now, take all steps to suspend all ongoing oil exploration and exploitation operations in the disputed area. Now, let me stress this, is that all ongoing oil exploration and exploitation operations in the disputed area.
Okay.
2, refrain from granting any new permit for oil exploration and exploitation in the disputed area. Take all steps necessary to prevent information resulting from past, ongoing, or future exploration activities conducted by Ghana or with its authorization in the disputed area from being used in any way whatsoever. And generally, take all necessary steps to preserve the continental shelf, its super-adjacent waters, and its subsoil. And then number 5, desist and refrain from any unilateral action entailing a risk of prejudice to the rights of Côte d'Ivoire and any unilateral action that might lead to aggravating the dispute. Now, there are those who say that Ghana won. The Ivorians are also claiming that
I was actually about to ask you what you make of this ruling.
I think it was largely favorable for Ghana. And I say largely favorable for Ghana to the extent that the Ivorians did not completely get what they wanted, which was to stop us. Okay, so they got something, but Ghana also got to carry on with its projects in the area. So 10, for instance, can go ahead. And for me, I think we should be looking at how this is impacting on projects we have in the area. One of the key projects we have in the area is a 10 project, and we're expecting that we're going to get crude oil from the 10 projects, crude and gas, oil and gas, from the 10 project by mid-2016.
Okay.
So will we get to do that? Yes, we can get to do that.
Okay.
So I think to that extent, yes, it was favorable for us. And to the extent that the Jubilee, the 10 partners or tallow oil, which is the main driver in the 10 field, is comfortable, then we're good to go.
Okay, Easy, let me hold you on and go back to lawyer Kwame Janto and pick his thoughts. You think the ruling has some positives for Ghana, or the positives overweighs the negatives for Ghana?
The major crux of the ruling was to stop tallow going ahead with exploration. They haven't been able to get that. But the way I see it in the terms of a case. You've got the prosecution and you've got the defense. And you've got to be balanced. It's a disputed area. The judges feel that in those areas that nothing has happened, let's have the status quo.
Okay.
And the status quo is that what they have itemized after granting the go-ahead for tallow to go. And they gave reasons. They gave reasons why, if they were to grant Ivory Coast's wish, what can happen. And one of the major things they said was, loss of financial investment. And that is key. And you see, if it had gone on, there would be revenue loss. Operators within the two boundaries, and let's not forget, the two boundaries in terms of Ivory Coast and Togo, operators would see it as contentious. Although, yes, so far, Togo, nothing has happened there, but who knows the future?
Okay.
There will be a huge effect on investors. There will be a huge effect on technology. There will be a huge effect on local content. And so, taking all these into consideration, the judges felt that, no, it's an ongoing process. It has already started. So for nothing at all, that should continue. And I don't see whether we should class it as win or lose. It is just an injunction that has been aborted. The most important thing is 2017, when the case comes up. When we win that one, then yes, we can say that we have won. But nobody knows how it's going to pan out.
Okay.
We know for a fact that at the present moment, tallow has been given the opportunity to go ahead with all the investments they put in there. $4.9 billion is no money you can take for granted.
Let me have you hold one more time and ask Easy. You think that the investments Ghana made in this, is that what has led to this ruling?
I'm not sure about the investments you're talking about. These are investments that have been put in, yes, partly, but mainly by the tallow oil.
In the area.
In the area.
Yeah.
I don't see it being that. I think I look at all this and I just feel that Ivory Coast thinks that there's a chance that they could get a dig at us. And so they took that opportunity. And yes, it's caused us some inconvenience. And to that extent, yes, Ivorians could be saying that, yes, they're excited
and so
about what
the judges, did they consider the investment in the area? You think they considered that? That's why they gave that ruling?
And indeed, they made it quite clear. If you look at the orders they gave, and you go through some of the considerations they read out. There was a preamble before they actually gave the final verdict, and it goes on to say, one of them, paragraph 99, says, considering that in the view of the special chamber, the suspension of ongoing activities conducted by Ghana in respect of which drilling has already taken place would entail the risk of considerable financial loss to Ghana and its concessionaires, and could also pose a serious danger to the marine environment, resulting in particular from the deterioration of equipment. So this in particular states that indeed the judges took into consideration the fact that it could cause serious financial risk to Ghana. But one other thing that came up, which I'd like us to have lawyer Kwame Janto also address his mind to, is the chamber is saying this. Now, the parties shall pursue cooperation and refrain from any unilateral action that might lead to aggravating the dispute.
That's right.
Now, this is one of the things that Ivory Coast sought, and that's number 5. It said they wanted Ghana to desist and refrain from any unilateral action entailing a risk of prejudice to the rights of Côte d'Ivoire and any unilateral action that might lead to aggravating the dispute.
Okay.
So the special chamber took that into consideration and gave them that. Now, I fear a situation where Ivory Coast thinks that anything, if they want to be belligerent, anything at all that happens in that area, which may not be drilling, but maybe something involving tallow, they could come up and say, we have a problem with that.
Yes.
It could aggravate the dispute.
Exactly.
And so they want to go back to ITLOS, for ITLOS to make a ruling on that. And I think that could disturb us. So this clause, I feel, is particularly worrying. And I don't know what Lawyer Kwame Jantua makes of it.
Yes, I'm going to ask Lawyer Kwame Jantua to react to that.
You know, let me make 2 points. The first point is that in terms of the investment, 4.9 million, yes, Ghana has invested some money with the FPSO. If it so happened that this verdict went in their favor, definitely the FPSO would have been a serious debt for us. Apart from that, Tallow has already drilled the 8 wells that they require for exploration and appraisal to go on. So I don't think they would drill any more wells with regards to that particular 10 project. It is well to go for 2016. Now, I'm not sure whether this ruling also affects Tallow drilling more wells within that disputed area, which is the 10 project. I don't see it because the judges have given Tallow the go-ahead to do whatever they need to do to get from exploration to production. So if that is the case, I don't see how that affects it. But anywhere around that area, we cannot give out any more blocks or fields without the notification of the Ivorians. So I don't want to see it as a win or lose situation because the race has just started.
But we're not supposed to drill new wells. And so will that have any impact in oil drilling? Because if, for instance, we have problems with any of our wells, will there be any impact?
With regards to the 10 project or regards to
exactly.
With regards to the 10 project, well, so far as I know, and talking to GMPC, the 8 wells that they have drilled so far is sufficient for us to start the process of heading towards 80,000 barrels at the end of 2016. So they don't see a problem. But I guess if they have to drill more holes, they'll have to go back to the Court of Arbitration to seek permission, including advising the Ivorians that this is what is happening. But so far, within that 10 project, it's good to go. There's no injunction on the 10 project. So I don't see it.
Well, earlier on, you said that this ruling shouldn't be anything that we should think is in favor of any country. But what could we have done to prevent Ghana from, getting to this situation?
We've left that boundary line so long. It's a question of negotiation. It's a question. We should have done this thing ages ago, and we've left it, thinking that it's good to go. But you see, in 1972, the then president of Ivory Coast, Ufo Boigny, agreed to this boundary line. He agreed to this boundary line. So why is it today the Ivorians are questioning it? And I've already told you that in extending Ghana's nautical miles where the what you call is concerned, Ghana's extending it, the UN used this boundary line to do it. And they did the same for Ivory Coast on the other side. And if they see that this boundary line is not what Ghana is supposed to use, why would they do that?
You think it's got anything to do with our exploration and production bill that we've not been able to pass to law?
Well, we have PNDC law 884, and I don't think it's got anything to do with that. The EMP law has got to do with internal, and when I say internal, it's got to do with the fields we've given out within the activity map of Ghana, which stretches from the Ivorian side to the Togo side. All those blocks in there, that is what it's for. It doesn't extend outside. So I don't see how the EMP law that we are trying to put through Parliament has any great significance with this case. Well, it wasn't quoted in any of the judgments that was made.
Yeah. Well, I would like to thank you very much, so much. We appreciate your time on today's big story. I'm getting back to Israel. Israel, there seemed to be I think signals we are picking is that both countries, from Cote d'Ivoire, for instance, are jubilating, and Ghana seems to also be happy that we're on the positive side. You think there's misinterpretation of the ruling or something?
I think, yeah, to some extent there's some misinterpretation, because from what Kwame was actually also saying, you get the impression that he also is of a view that may not quite be what, or different from what I am thinking.
Okay.
I generally think that indeed the ruling says that there should be no new drilling, and that's a fact.
Okay.
But he intimated that if indeed we wanted to drill, it becomes necessary for us to drill in new wells, we may have to go to ITLOS. That to that extent says that yes, the Ivorians have been able to hold us in check. Okay. Hold us in check by saying that you can't go beyond whatever you've done so far.
Exactly.
Now, my understanding is that yes, Talo has gone ahead, it's drilled 10 wells. And the 10 wells that have been drilled so far, yes, indeed, without doing any further drilling, they can't deliver first oil in 2016. So, I mean, for me, I think that so long as we have that, and so long as Talo is comfortable with the ruling, and we're getting some indications that the investors are also excited, their shares, you know, appreciated upon here, you know, after the news came out. So clearly they're comfortable with the ruling, and I think it sends out the right signal. So investors who are out there may want to also come into the Ghanaian economy, or come into the sector, that things are fine. Yes, we would have to wait until 2017 when ITLOS comes out with a final ruling to say whether or who has what. And it is at a point that we can say maybe one or we lost.
I pray so that it comes in our favor. But meanwhile, African Center for Energy Policy says even though this ruling will not affect our drilling of 20,000 barrels of oil per day, it doesn't look too good for Ghana.
For Ghana, I mean, it has some implications, I mean, both positives and negatives. It is positive that we are allowed to progress on the 10 development, which is quite significant because we are making about $5 billion investment on that project. And any attempt to halt that project could have had far-reaching consequences, you know, because they are financed largely by loans. So I think that's why the court made sense to say that we can continue, you know, with those projects, and that is the larger bit of this whole ruling. But Cote d'Ivoire also had some interesting reliefs that were granted to them. One being that there cannot be any further drilling in that disputed area. Even the implication for 10 on that ruling is that we can't drill, even if it becomes necessary for us to drill more wells in our attempt to produce. Because now they have 10 producing wells that have been drilled. If they have to drill for water injection or for gas re-injection, they cannot do that because that's what the ruling actually says. If they encounter any difficulty that requires additional drilling, they cannot drill. That will also have implication on the entire financing arrangement of a project. And that.
So, Izzy, going forward, just in a second, you think what should Ghana be doing to prevent such things?
I think it wouldn't be too bad if we continued having negotiations with the Ivorians.
Many thanks to you, Israel. I appreciate your time in the studio. We'll be back shortly with the Joy News Interactive, your most authoritative interactive segment.